regard to the government order dated 19 September 2022, whereby the government proposed to create supernumerary posts. Kindly underline this: government proposed. And the cabinet memo says, well, the School Service Commission proposed. These are very interesting feature. And whereby the government proposed to create supernumerary posts for assistant teachers. I say that the state government order came as a policy of the government for accommodating waitlisted candidates. That is also the government stand. The commission, merely being a recommending authority, has no role to play other than implementing the directions of the School Education Department, for which issued the notice dated 14th October 2022, which is merely a schedule for conducting and counseling of assistant teachers for work education, physical education. I deny that the notification referred to are in complete violation of Rule 12 for the Rules 2016. I say that Rule 12.4 deals with the primary, upper primary teachers.
Misquoting. This 12.4 is misquoting.
Misquoting. 12.4. 13.4. 13.9. That I have placed also on the last occasion. Then that means I deny that there has been any violation of Rule 39 of the Rules 2016, as the panels and wait lists were published according to the state rules 2016. But this is a very important submission on behalf of the School Service Commission. Therefore, this wait list, Millard, is related to 2016 selection, where ratio 1:4 was maintained. With regard to the petitioners being called for verification after creation of supernumerary post and creation, I say the question did not arise that the supernumerary posts were created for leftover waitlist candidates who are actually successful candidates who could not be recommended for want of vacancies. And my rule, my lord, prescribe the detailed method of, my lord, declaration of vacancies at the time of advertisement and final vacancy 15 days prior to final publication.
Yes, that Rule 8 possibly is.
Rule 8.
Kindly explain this situation, this 1:1. Supposing
I just give a sugar. Now, my lord, I have vacancies, suppose X.
No, first of all, this supernumerary post would be, treated as vacancy.
Of course, so. But they admit that these wait list candidates, they could not be accommodated because there is no vacancies. Vacancies were notified as per the rules. And, my lord, as per the notified vacancy, my lord, they have invited for further interview, for a further schooling or merit assessment, 1:1 ratio. If there are not 100 vacancies, they have to invite 140 people. By that process, the list is prepared. And according to the merit position, the top meritorious persons who goes to vacancies filled up. The rest persons who are called for interview are placed in the waiting list. Why waiting list? Suppose a person who was found to be in the merit panel within the 100 declines to join. Then, during the validity of the panel, person at the waiting list is offered.
No, whether this can be treated as vacancy.
Of course.
If it is treated as vacancy, then 13
has to be first.
Has to be.
No, that they say the consistent pillar stand of the authority.
And in that event, the petitioners had a chance of
everyone had the opportunity, to get a call.
How then? By the cutoff mark will be lowered.
These are the now new vacancies, and the persons who are waiting may not be in the waiting list which has exhausted. They are also entitled to participate. When there are a vacancy, then you have to fill it up according to the procedure laid down under the law.
Mr. Varja, make it clear. Now, waitlisted candidates, why the candidates have been put in a waiting list? Because there were not sufficient vacancies there.
Therefore, these vacancies become beyond the declared vacancies.
Beyond the declared vacancies.
If it is beyond the declared vacancies, then you cannot appoint from the said recruitment process. But
How
it's-
your chance come then?
but
If it
then
is, if
this
it is,
vacancy now we have created X vacancies, it's open, who are entitled to apply as per the EGB, apply for these vacancies.
so this is a natural selection process,
Normal selection.
normal selection process. But in a situation where if you treat this as vacancies,
Hmm.
if you treat this as vacancies, how your
I,
chance?
I will not treat this as new vacancy. They say these vacancies are created after the selection was complete, after the appointment procedure was complete. Therefore, these are vacancy creation. They say we have created this for the waitlisted candidates. Why waitlisted? Because they could not get chance in the declared vacancy.
Now, I want to understand one thing: how if it is treated as vacancy,
At least.
how the petitioner's chance comes
Yes, but if it is a vacancy, then what would be the duty of the government?
to declare it and you take it in the new selection process. In this selection process, if these vacancies, these supernumerary posts are treated to be a vacancy,
Then what you have to do, you have to invite 1:1 ratio all the persons who are waiting. May not be the waiting list, but their standing might be below the so-called waiting list. But still, they would be without.
but they must have the beyond the cutoff mark.
Yes, might be so.
1:1.4.
Now, cutoff mark changes as soon as you create the vacancies. The cutoff mark was created for the purpose of filling up the declared vacancies. That cutoff mark cannot come for the purpose of consideration of new vacancies.
So you say that as soon as it is a vacancy, your whole thing
Whole thing has to do afresh.
including the fixing up the cutoff mark.
Absolutely. Everything would be changed. You admit that we created this vacancy to quell the administration. I mean, the agitation. That is the admission in the cabinet memo. Since the people were agitating, to stop the agitation, we have decided to create post for the agitating group. Can state do this?
At that point, আমাদের আর waitlisted position same ছিল, can I expect?
And since Milord and since the wait list conception is related, Milord, inextricably with the selection procedure of 2016, this wait list has nexus with the select list. If the select list is complete, wait list Milord vanishes. Apart from the question of Milord expiry, the purpose of wait list Milord is completely abolished as soon as Milord the vacancies are filled up.
So creation of supernumerary indicates that vacancies have been filled up. There is no vacancy has occurred due to non-joining or otherwise.
But if non-joining Milord, then the person who is at the wait list, he will be offered. And
But
this
creation indicates that there is no such situation.
vacancies are complete. We cannot appoint you. Don't agitate. We are creating vacancy for you. This is Milord fundamentally against the basic principles of Article 416 and in violation of the recruitment rules. I shall take your lordship to law later. But I am trying to emphasize on the facts that this is the persistent stand of the state and the School Service Commission as well, that the vacancies were created for a particular section. It may be for a privileged section. I use this term. Then may I complete this not paragraph 9. They were dealing with 13.9, 12.4 was a mistake. They have also may not say. They have, however, just down the middle. However, I deny that there has been any violation of Rule 13.9 of the Rules 2016 as the panels and wait lists were published in accordance with the Rules 2016. This is, in my humble submission, full stop. You admit that you have published it. Therefore, exercise of power under Rule 2016 is exhausted. Then they say, and in the ratio 1:1:4, with regard to the petitioners being called for verification after the creation of supernumerary post, I say that the question did not arise as the supernumerary posts were created for the leftover waitlisted candidates who are actually successful candidates who could not be accommodated for want of vacancies. How could they successful? We are also successful because we could not be accommodated in the vacancies. If there were vacancies were created, I create 20,000 vacancies. Everybody is successful. This statement of SSC is very interesting. On the other hand, petitioners on the other hand were unsuccessful candidates who were not even eligible for participating in the personality test. Because this personality test was vis-a-vis declared vacancy. If the vacancies initially was which you have declared and subsequent vacancies, automatically you have been called personality test. But this statement of School Service Commission.
So it cannot be says that you don't have any interest
Well, I am most
in
vitally affected.
creation of the supernumerary
This
post.
is absolutely, that if I may use some, the argument doesn't hold any water. This paragraph 9 of the School Service Commission affidavit is very important and interesting. Then kindly come to me, Lord. In paragraph 10, they are dealing with OMR sheets. I am not now troubling my Lord with that. No, actually.
You have to, you may have come back again.
I have to. I have to. Now, Lord, this is interesting. Kindly come to paragraph 14. I say, Lord, this is important. Because I had pleaded before your Lordship, which has been accepted by the division bench, upheld by the Supreme Court, that after the creation of this, School Service Commission filed application before the court saying that we have created this post to accommodate illegal appointees. As soon as we took up the point, they wanted to withdraw. The Honorable Court refused. They preferred appeal. Appeal court giving reason judgment refused. There's no, it cannot be withdrawn. Now they are dealing that. With regard to supplementary affidavit, I say that the state supplementary affidavit has been filed annexing 1 CAN application so-and-so, which has been filed in connection with WPA so-and-so, Shandip Prasad and others, which has no connection with the instant heat application. As the case of Shandip Prasad deals with the selection of Group D staff, which is a totally different selection process. Moreover, the purpose of creation of supernumerary as prayed for in the state CAN application is totally different from the purpose of creation of supernumerary post. That I have placed with that cabinet memo, this stand that is betrayed that. As proposed by the government order the 19th May. Hence, the question citing the CAN application while challenging the government order does not arise. It may be noted that the Commission has given specific written instruction to the advocates to withdraw the state CAN. But the facts are out. But the cat is out of the bag. Now you cannot just say, I will put the cat again into the bag. Therefore, the both state and School Service Commission, Lord.
For a minute, a division bench judgment.
I paste that division bench judgment. But I